So the next panel is on tactics for co-accused cases. Madam Justice Michelle Fuerst was appointed to the Superior Court in 2002. Her Honor controls the Central East with an iron fist. If you want an early date, you will often get one. If you don't want an early date, you will often get one. Justice Fuerst, prior to her appointment, was an accomplished advocate, having been a partner with Gold and Fuerst. Her Honor has been committed to legal education throughout her career, being an adjunct professor and having published numerous books and academic articles. And Justice Fuerst, importantly, a past president of the Criminal Lawyers Association. I've had the pleasure of working with both David Bayliss and Nathan Gorham at the same firm earlier on in my career, both formidable advocates. David Bayliss has focused his energies on provincial and Superior Court trial advocacy with an emphasis on charter rights litigation. He has conducted numerous homicide defenses with an enviable rate of success. You will not find a more experienced trial lawyer than David Bayliss. Nathan Gorham is a partner at Gorham Vandebeek. Mr. Gorham practices in both New Brunswick and Ontario. Ontario alone just wasn't challenging enough for him. Somehow he found the time to earn a doctorate of judicial sciences and is an adjunct professor at UNB. Mr. Gorham also regularly defends complex homicide cases with an enviable rate of success. We chose this panel because Justice Fuerst presided over these two legal warriors during a rather friendly little cutthroat homicide trial in the last couple of years. So here we are, tactics for co-accused cases. Looking forward to this panel.
Thanks, Adam, and good morning, everyone. As many of you know, when you have a case that involves one or more co-accused, you're fighting the battle on multiple fronts. You've got the Crown on the one hand, but you've also got counsel for your co-accused on the other to be concerned about. So, David, before we get into the real issues that we want to talk about, just by way of background, I am aware that you and Nathan once had a case in which you each represented a co-accused. So how did that go?
It's the second worst case I've ever had to do. I won't tell you about the first one, but it was, we were all on this together back in 2012. There were just the two accused. There was no jury. Fortunately, we elected to be tried by Judge Fuerst. It was a very nasty home invasion where my client was the alleged mastermind and Nathan's client was just along for the ride. That's not how it turned out. They were both acquitted, but it was sort of a very difficult trial. And Nathan and I didn't speak, I think, for a couple of years after that, even though we were in the same office. So.
Well, can I say a word about this?
Absolutely.
It's a little bit of an understatement what David's described here. So when I got to the Pinkovsky's office as a student, David was a formidable force in the office, and he worked the latest hours. His door was always open. He was always winning cases, and he was always offending people because he would do whatever unpopular thing or any unfavorable or apparently despicable thing from the Crown's perspective if it was the right thing to do. And so David had a reputation of, if it was right, he was going to do it, and he didn't care who he offended in the process. And so David mentored me along with a variety of other people. And so when I was a young lawyer and I got the opportunity to do a case with David Bayliss, I thought this is going to be fantastic. I've never juniored with him before. The conventional wisdom is you don't do a cutthroat. It's better to get along. And so I thought this is going to be a great experience. Me and David, I'm going to get to see how David does this. And it'll probably be easy for me too because I'll be second and David will be doing all the work. And it'll be very, very, very fun. And then as trial was approaching, I just said, wait a minute, David's moving a bit weird here. It seems like maybe things are not as they seemed. And then there's a suggestion, as I recall it, let's re-elect in front of Judge Fuerst. And I thought, okay, sounds good to me. My client has a fairly easy identity defense, and David has all of the heavy lifting to do. Fast forward several weeks later, and David was telling me at one point that Judge Fuerst wasn't going to listen to me because she knows his reputation and I'm just a newcomer. And now I was thinking, okay, we've got a problem here. But what you'll find out is that as we talk about this anecdote, when the case started, I found out that basically every allegation that was against David's client was now against my client, according to David and David's client and his father, who described a very vivid vignette of Sunday morning pancakes and a very wholesome family that was interrupted by my evil client who came over with the idea of a home invasion robbery. And so I credit David for teaching me a very difficult lesson in my career, which is don't ever trust your mentors in a cutthroat defense. And also, we have to choose our ethical obligations over any friendship or warm feelings we may have for the counsel for the co-accused. And so that's my truth on it. David may disagree with some of that, but and there's more, but I'll leave it at that.
Yeah, just one point about that trial, which was a bit odd, was that my client's Nathan had an identification defense until my client's father was called, not by me, but by the Crown Attorney. So that was all done by the time we got to the defense case. I just want to point out that this is the format we're doing here. Is very practical, but the paper that's been done and the PowerPoint goes into the legalities of it. We're not going to focus on that. We're just going to focus on the terrible experience of having a cutthroat trial.
All right, and you do have a very excellent paper in your materials prepared by David and by Nathan, and I suggest that when you have time, you take a look at it. It's very helpful. So as a jumping off point then, David, can you, at a high level, just speak a little bit about the Supreme Court of Canada decision in Crawford in terms of what does it tell us about what can arise and what may be permissible in a co-accused case?
Sure. I'm trying to get this PowerPoint working.
The title slide is up behind you.
It's not.
But it's not showing on the screen.
Adam?
Try that one. There you go.
Oh, here we go. Okay. All right. All right. So in Crawford, the accused Crawford attacked Creighton. Creighton wanted to cross-examine Crawford on his right to remain silent, pretrial silence, and that issue hadn't yet been decided by the Supreme Court. And they decided, as you can see from the main quote there, that yes, indeed, you can cross-examine a co-accused on their right to the fact that they exercise the right to remain silent. The appeal was allowed on the basis that, well, you can see the quote there, the Crown has a hand tied behind the back, but the co-accused does not. The appeal was actually allowed on the basis that the judge failed to give the proper limiting instruction to the jury. In other words, Creighton was entitled to attack credibility by challenging the failure to give a statement to the police, but the jury could not use that exercise of the right to silence on the issue of guilt or innocence. And the judge did not give that instruction, so the appeal was successful. So bottom line from Crawford, and you can see that we've gone through a list in our paper of all the different things that the co-accused can do to you that the Crown can't.
So Nathan, bearing that in mind, why do you think it's important to know your client in your case? It always is, of course, but in the context of a co-accused.
So I think my view in one of the things I learned in the case with David and after that is that when you're looking at a case with a co-accused, your ethical obligation is to advance a cutthroat defense if that will assist your client according to their instructions, and if they instruct you to. And so you can't have this idea that I don't want to do it because that's not the good way or the right way. You have to do it if it's what flows from your client's instructions and your client's account of the events. And so the first thing you need to ascertain is what does your client say about things, and how's that going to factor into a defense. So you need to figure out what your theory of the case is based on what your client says. And then once you understand what your client's theory of the case is, you have to weigh what potential negative consequences will come from attacking the co-accused. And that includes things like what David just talked about in terms of character evidence that's going to come in against your client and so on. But you can't make the decision on whether you're going to advance the adversarial defense until you think very, very clear-eyed about what's your client's account of the events, and is it necessary to actually go against the co-accused in order to advance your client's account of the events, and therefore your theory. And so one of the things I've seen since the lessons I learned in the case with David is lawyers in co-accused cases will come into the trial not being clear about what their theory is, and it's almost like they haven't quite pictured how everything's going to play out. They haven't committed to the way that they're going to do it. And so the case starts, and they're stuck in front of the judge or the jury in a non-committal position, okay? Taking a position, it might not have been my client, but if it was, then my client was acting as a party who was duped by the co-accused. Okay, and so they come in with this double-barreled approach that's not a commitment to anything, and it makes, nobody likes that, right? Judges don't like it, juries don't like it, and it makes them look bad, like they're not decisive, and like they don't actually have a truthful theory behind what they're saying. And when they do that, it leads to a whole series of negative consequences, I find, in terms of evidentiary rulings, in terms of the way that people view the case, the way that the jury or the judge interprets what's going on there. And they might be totally right to do it because the principle against self-incrimination and right to silence and so on, and taking clients' instructions. But the fact of the matter is, people listening to that don't like it. They receive things much better when they see someone who is advancing what they say is the truth, and they're decisive about it, and they're pounding away at their version. And so my view on this is, early on in the case, you have to sit down and think, what's my theory based on what my client says, and then picture how that theory is going to play out down the road, and then make your decisions on, if I advance it this way, do I need to take an adverse position to the co-accused? And if I do, what potential ways are there to mitigate some of the damage that's coming back against me, the blowback from the co-accused if I advance it this way? And so I think you need to make that decision well in advance of trial, and then think clearly about it as you approach trial, to try to advance your client's side, but also to mitigate the blowback that you can get from the co-accused.
And as you'll hear as we move along through various topics, it's important to think this through, because one of the implications may be that you have to stand up at some point in the midst of the trial and say to the presiding judge, in the absence of the jury, if there is one, there's an issue that I need to raise with you, Your Honor, and it's going to involve, on your part at that point, providing some disclosure of exactly where you're planning to go with the case. But we'll come back to that shortly. So, David, something that is creeping into criminal law from other areas is the joint defense agreement. So what is it? What's its purpose? And should you be thinking about entering into that sort of thing?
Sorry, it's a question, Your Honor, the joint defense, was that?
Joint defense agreement.
Yeah, I think we're sort of, okay, let's go to that part on the slide then. Yeah, okay. All right, so the Pollock case in the materials, sorry, the Havishire case, as mentioned in the materials, the Series 6 murder case, is an example of how a joint defense can go wrong. But as Nathan mentioned, what you have to do at the beginning of these cases and before they start is decide what you want to do. One of the options is to have a cooperating defense, where you agree, and there may be just one other counsel, or there may be multiple counsel. And so if you do want to have a cooperating defense, and that's another reason you really have to know your case well, because as in Havishire, what happened in Havishire was that one of the people in the cooperating defense went offside and pled guilty and testified for the Crown. So the relevance of this, I think the most important relevance of this is the issue of privilege, and Havishire discusses that. Solicitor-client privilege does not apply, but litigation privilege does apply to joint defense meetings. In other words, anyone who's done long trials knows that people are wandering around. If the accused are out of custody, there's meetings involving the counsel and the accused persons. And all of those meetings, arguably, are protected by litigation privilege. So I've seen transcripts where Crown attorneys cross-examine accused persons about whether they spoke to the other client's lawyer or whether they spoke to the co-accused about the case. And that's when you jump up. If you've got a joint cooperating defense, you can jump up and say, look, that's privilege. You can't ask my client about his conversations with other clients because counsel were present. So any meeting where a lawyer is present with accused is arguably covered by litigation privilege. The problem is, once someone leaves that agreement, it's over. And all of those meetings become an open book, and that's what happened in Havishire. Havishire applied for a voir dire, to have a voir dire, and the judge said, no, there's no point in it. There's no litigation privilege once one party's left the agreement. So joint defenses can be great. You should try to work together with counsel to the extent that you can. But it's another example of where you really, really have to know what's coming down the line. If you're not prepared and you don't know exactly what your client's vulnerabilities are, it can turn into a real disaster. So.
Does it have to be in writing, David?
Pardon?
Does the Havishire type of agreement have to be in writing?
So does it have to be in writing?
Oh, yeah, okay, that's a good point. I've never seen a written agreement in the criminal context. The joint defense agreements are very common in civil law. They run 8 to 10 pages. And actually, Adam provided me with one, and they don't exist in criminal law, thankfully. In Havishire itself, I don't believe there was a written agreement. It was simply the privilege is there. I mean, I suppose you can have you could put something in writing, but I've never put it in writing in any of the long cases that I've done. It's a privilege that's there, whether or not you have it in writing.
If I can say a practical point on this, my personal view on this is don't say anything to a co-accused counsel, and don't say anything to a co-accused that you wouldn't be happy if it came out in court. Okay, so don't say anything that you wouldn't stand by and be pleased that it's being announced in court. Don't say it unless you're willing for that to happen, because it can happen, and it can, even if you're totally above board what you're doing, it can still make you look bad in the case. Because my other personal view on this is judges and juries don't love the idea of defense lawyers all coming together and having secret agreements and then ganging up on the Crown. They may not say it, but it seems to me that portrays a negative image, that the Crown is outnumbered, or that there are defendants whose evidence is being shared one to the other, or lawyers are talking to the defendants behind the scenes. I don't like the optics of it. Maybe there's a case where the optics would be okay, but I don't get involved in that because I don't want to be involved in presenting that sort of image. If I feel that if I have a case and I say to myself, this could be adversarial because this co-accused has said things and done things that are going to have to come out as part of the truth, but I want his or her lawyer to understand it's not worth having an all-out cutthroat defense over this, then I might just go to the lawyer and say, look, it's true that your client threatened my client. We have that in text messages. He's going to have to take a hit on this in front of the jury because it's true, but I'm not working to sink him in the case. I'm just working to advance this part of the truthful narrative, and so let's see if we can work together to the extent that we can. I might have a conversation like that, but I certainly wouldn't, my own practice, get involved in talking to the co-accused about the evidence, and generally, I personally try to stay away from agreements to work together.
Well, I can think of one case going back to 2007 in Brampton, where the judge, all the accused were in custody, there were 4 of them, and the judge cleared the courtroom and invited all counsel and their clients to have a discussion, and we did that. And there's lots of other contexts, I find, where you speak to, I mean, it depends on the type of situation you're in. If you're in a situation where you're into a cutthroat and you want to kind of limit the damage, that's one thing. But if you have a cooperating defense, you have to speak to each other. You just can't do it without speaking to each other. And you have to try to protect those conversations as much as you can. And they don't necessarily need to be formal meetings, but you step into the meeting room beside the courtroom and with the other counsel, maybe some of the accused are there. I mean, don't forget, on bail papers, there is always an exception to allow the accused persons to consult in the presence of counsel. That's there for a reason. Sometimes you do need to get the accused people to speak to each other, and if you're there with them, those conversations are protected.
If I could just make one point and counterpoint. I think the one you're talking about was a resolution discussion where there was going to be a joint resolution in the case and everybody needed to get together to
First example was,
hammer
yes.
things out.
Yeah.
I'm not saying David's wrong on this from my perspective. I just can't picture a scenario where I wouldn't just be satisfied of having a conversation with the lawyer and then letting the lawyer do his or her work with the client. And then if I can trust the lawyer because I feel that the interests are aligned, then I can trust them. I don't need an agreement, something that is going to portray it like we're all in cahoots together. Like in the case with David, I went to him and said, "What's your client's dad going to say?" And David said, "I can't tell you." And so then I realized, okay, well, there's a problem. And then I went to the Crown and I said, "You better get a statement from this guy because you're going to call him and you think he's going to identify the son. He's going to do more than that because David Bayliss doesn't come to a case unprepared. Something's going to happen here." And he would have told me. And David said, "I'm not going to tell you." So then if David had
I
told
was
me...
just trying to teach you.
Right.
All right, and I take it, regardless of the fact there may be differences of opinion about what you do in a joint defense scenario, David, you would not be approaching Nathan's client behind Nathan's back for a chat, just so we're all clear.
Yeah.
All right?
Yeah, no,
There are ethical
Yeah.
limitations here, and we don't want to send the message that somehow this would be okay, because I don't think it would be okay. I think we all agree.
It was specifically what...
That you, behind Nathan's back, approaching his client.
Oh, no,
to
no,
have a
no, of
chat,
course
just
not,
so we're
no.
really
No,
clear
that
that
would
this
not
is,
be
that,
appropriate.
regardless of the difference of opinion about other things here, we all agree that's outside the parameters of ethical conduct.
No, that's, I mean, the only situation in which you would communicate with a co-accused is in the presence of the co-accused lawyer.
So, Nathan, in a case where you now are leaning in favor of running an antagonistic defense to David's client, what are your client's vulnerabilities? What are you going to be concerned about? You've talked about knowing your case and your client, but what are you now particularly concerned about?
Well, I think you need to be concerned about you're going to create another Crown who's trying to prosecute your client, and there's a negative side of that, obviously. There can also be a beneficial side of it if the jury's seeing that you're being ganged up on and it appears that you're the one with the truth on your side, then it may have a benefit. But I think generally you want to think in the beginning you're going to create another enemy is one thing. The other thing that you need to think carefully about is the type of stones you throw at their house are going to come right back at you. And so if your client has some sort of mental disorder that makes them inclined or disposed to commit violent offenses, or if they have a violent background, or if they've done other nasty things, you need to recognize that if you start claiming things about the co-accused character, then those things about your client may be coming back to you. And so you want to be careful that if you live in a glass house, don't throw stones. And if you don't, then start throwing. And those are the two main things that I think about in terms of, I guess the third thing as well is that a judge or a jury may lose patience with the defense if they see that there's an antagonistic fighting back and forth, sort of squabbling picture that's going on. We won't ask you to comment on that. We won't ask you to comment on that, Judge Fuerst. But I remember David talking about the CLA days or something in that trial, trying to exclude me as somebody. Anyway.
Just again, it all depends on how you're going to run your case. And in the paper, we sort of go through the different scenarios. You can be the prosecutor, or because you've got all the goods on the other person, or you could be playing defense because they've got all the goods, or it could be that everybody has bad character and all kinds of skeletons in the closet. And even in that situation, you need to sit down with your co-counsel and try to minimize the damage. There is a way to do it. I mean, in our particular case, as difficult as the trial was, the clients were acquitted. Because I think we did hold back to a certain extent. It could have been actually worse than it was.
Okay, well, I might remind you, I think the presiding judge in their reasons indicated that neither client's testimony was worthy of belief. Just saying, but there was another route to acquittal that was open to each of them. I just have that vague recollection, Dave.
I think Justice Fuerst did it so that Nathan and I wouldn't kill each other.
All right, so let's talk about the issue of bad character and antagonistic defenses, because this is, I think, the area that becomes very problematic. It's problematic for counsel. It's also problematic for the presiding judge, who is going to likely have to make some rulings as things unfold. So let's start, David, with professional and ethical constraints on counsel where there's a cutthroat defense that's going to involve bad character evidence.
Okay, I have to go back a couple of slides here then. Adam, I can go forwards, but I can't go backwards. How do I go backwards on this, Or I just cycle through? I'll just cycle through. Okay, well, you got the PowerPoint and the materials anyway. Yeah, so there are considerations. The Pollock case talks about a couple of things, and there's a lot written on this in the paper. But the big problem in Pollock was, and it was a bad character situation, and the counsel for the co-accused just kept bringing it up without giving any notice. In other words, popping up in the middle of the trial with all kinds of very prejudicial evidence. And so it got to the Court of Appeal, and the Court of Appeal, Morrison was the co-accused. Morrison's appeal was unsuccessful, and Pollock's was successful, basically because the trial had been rendered unfair by the conduct of Morrison's counsel. By raising these issues without any notice to the court, and as the Court of Appeal pointed out, basically once you ask the question, it's too late. So the Court of Appeal made it very, and this is one of the professional, the tactics that are not acceptable, are raising issues of bad character without giving notice to the court. You don't have to give notice prior to trial, but you have to stand up during the trial and ask the jury to be excluded and say, I've got something really bad to say about Nathan's client here, Your Honor, and I'm asking you to approve it. So that's the main thing that you have to do when you're dealing with bad character evidence is a requirement for notice now, and there never used to be. And the court goes into, I quoted a couple of paragraphs in the paper, where the court's very specific about the role of counsel in these cases, because they're difficult cases. You have to defend your client to the best of your ability, but there are limits on what you can do, and the court in Pollock points those out quite clearly.
All right, and just to underscore, when Pollock talks about giving notice, it's not talking about now you have to prepare a written notice of application and file it 30 days in advance, et cetera, et cetera. We're talking about, as David indicated, you're going to have to at some point stand up in the midst of the trial and give oral notice that there is an issue to be raised in the absence of the jury, and that's essentially, I think, what you did, Nathan, in the case that you've been referring to.
And there's one sort of subtlety about that, where maybe it's not that subtle, but I mean, it applies specifically to bad character evidence. The notice requirement does not apply, for example, if I wanted to cross-examine your client on his failure to give a statement of the police. That would not require notice. So you're not required to give notice in any situation where what you're planning to do, whether it's accusing someone of having read the disclosure to construct a story, or you want to address the jury on the client's failure to testify, as what happened in Crawford. You don't have to give notice on those things. The only thing you have to give notice on is if you are calling some bad character evidence. And you need to read Pollock carefully because it sets out a test for the admissibility of bad character evidence by a co-accused. So it's only that you have to give notice for it. I mean, it never helps your client to give the other side disclosure that you don't have to give them.
I'd add one thing on the timing of the notice. So raising the requirement of notice is to fulfill your professional obligation to the court, fairness to the court, fairness to the co-accused who may want to raise an objection. But if you say to yourself, I'm going to be eminently fair, and I'll raise this really early on, as early as I can to show how fair I am, then you're failing in your obligation to your client at that point in time, potentially, because the relevance of what you have, the bad character evidence, comes into focus once the court knows the evidence in the case, but also the position taken by the co-accused. Okay, and so you can give notice too early and do it in a vacuum where it's not clear what position the co-accused is actually taking, and then the court is left to try to decide this without understanding the nature of the attack that's going to come against you. Okay, and so you need to think to yourself, okay, I need to do it early enough to be fair to everyone, but also I need to work to make this record crystallized in the sense that it has become clear what the co-accused is doing, it becomes clear what the co-accused is saying, and then you can say to the judge, look, they're actually trying to make it appear that my client is more likely to be the person who did this because of my client's prior bad behavior, okay? And then if you have a picture on that, now the timing is perfect for you. Now you stand up and you say, I actually have some bad things that I can say myself, okay? And I think you need to, part of the concern here is that you need to strike the balance in a very difficult situation between fairness of the court and the co-accused and also gaining a proper advantage for your client.
And just bear in mind, you can't ask that the accused or the co-accused be excluded from the courtroom during the discussion. It's their vital interests at stake. I can't think of too many situations where it wouldn't be more at stake than this. And so don't make that mistake, especially, if you're dealing with a judge who you feel may not have as solid a grounding in criminal law as you do, if I can put it that way. Be really careful that you don't lead a judge to say, and now the 2 accused or 3 accused, you're going to step out of the courtroom because this is a discussion we're having in the absence of the witness or potential witness. So let's go on and talk a little bit about some other practical implications in these cases. So Nathan, what about the decision to choose to go with a jury or a judge alone if those options are open to you? How is that impacted in a case where you've got 1 or more co-accused?
I don't remember this one being on the list.
It's on the list.
It's probably my failing. I approach it from the same perspective that I would approach any case, thinking if the case is going to involve straightforward credibility findings that make it so that 12 people with their collective common sense might be the best experts on it, then I'll lean that way. If it's a case involving identity evidence or possession evidence, then obviously a judge who's well versed in these principles may be better suited for the evaluation of the issues. After that, the one consideration that might come into play is that the Pollock rule on fairness may change slightly, in my view. I don't know if anyone agrees with this, but may change slightly, in my view, in a judge-alone case. Because in a judge-alone case, I think you still want to be careful about not introducing presumptively inadmissible evidence without giving notice. But the potential damage or the stakes if you tread a bit too far before you make the motion aren't the same in a judge-alone proceeding. And in the case that we're talking about, that David and I did in front of Judge Fuerst, I was actually cross-examining the co-accused, asking him about his potential involvement in gangs and so on, and tattoos that he had. And my view was that he had put that in issue already by his examination in chief, but I think reasonable people could have differed on that.
Yeah,
And
that's when Justice Fuerst accused you of assassinating the character of my client.
And Judge Fuerst, I remember this very clearly, intervened. I could already tell that maybe my cross-examination was getting a little long in the tooth on this point, but I wanted to set up Bayliss' client as best I could before I pulled out my 3 inches of Facebook posts that I had on him. But Judge Fuerst said, I know this is a judge-alone trial, but still I have an obligation to protect trial fairness, and you're asking questions about character, and at a point, there's no objection, but at a point I need to inquire. And I interpreted that as reference to I think what is the practical reality here, that in a judge-alone case, the stakes aren't quite as high, and there's a little bit more room, a little bit more leeway for you, as opposed to in front of the jury. So I think that's a consideration as well, that you're not going to be in the pressure cooker quite as much if it's a judge-alone trial on balancing these admissibility issues.
Yeah, I think any time you have a case with a lot of bad character evidence, a fair judge is going to be better than a jury in most of those cases, in my opinion. It's, judges hear it a lot and jurors don't, and sometimes it's a pox on all your houses, and I think that might have happened if we had a jury in our case too.
So, David, what about the issue of the indictment and the placement of your client in the order on the indictment in a multi-accused case? Is that something that is a cause for consideration?
Yes, not that you have much control over it. And Justice Fuerst and I had a discussion about what the actual procedure is in the Crown's office. And my experience was that the Crowns would usually put the guy that they wanted or accused that they wanted the most, they would put them first, because it's very disadvantageous in most cases to be first on the indictment. And then I've heard more recently the Crown that it's being done alphabetically, so I don't know exactly what the procedure is. But if you are in the case that Nathan and Justice Fuerst and I did, I was last on the information in provincial court, and then somehow I suddenly became first on the indictment in the Superior Court, which I guess my client was the bad guy, and that's difficult because you don't, once your client has testified, is done, there's nothing you can do about his cross-examination. You don't necessarily know what the cross-examination is going to be. He can't respond to people who testify after him. So I don't know. I don't know what the procedure is nowadays, whether there's anything formal, but really we have no control over where we end up on the indictment.
All right, I understand we have about 5 minutes left, so Nathan, would you like to talk a little bit about documenting instructions from a client in a case with co-accused?
Do you want me to take that, or are you going to?
Yeah, go for it.
Yeah. Okay, so there's a part in the paper on this as well, and see if I can get the right slide up here. No, forget it.
See what a bully is.
So it is important to get instructions in the context of a joint trial, because they often end up in the Court of Appeal. And they end up in the Court of Appeal sometimes because someone's complaining about something someone did, or sometimes something someone didn't do. So the instruction that I think I get more than any other from a client is, don't attack so-and-so, like do not cut any throats. Usually there's a lot of reasons. Maybe they're in custody, they're on the same range or close ranges, or there may be all kinds of reasons why a client would take that position. But you could have a real problem, because if you don't get very clear instructions on that, and then your client gets convicted, and he speaks to the appellate lawyer and says, well, so and so had all this. He had 3 inches of Facebook stuff. My lawyer never asked him anything about that. So, then you're in an ineffective assistance of counsel situation. So you've got to, and sometimes clients won't sign written instructions. What I do in that situation, just to make it contemporaneous, is I'll send myself an email, or I'll send my practice manager an email saying I got this instruction from so-and-so, so that if there is an appeal, I can demonstrate that the instruction was there. and that's why I did it that way. But it's very, the cutthroat scenario is a situation where you really should be careful about your instructions.
All right, so Nathan, last but not least, the case comes to an end. Your professional work goes on. What do you do about the fact that you and David maybe didn't have such a friendly relationship during the trial?
We didn't speak for a while. And then at the next Christmas concert, in the joint office Christmas concert, I gave a talk and made fun of Bayliss. And then Bayliss told me I was an asshole, and we went on.
And then he invited me to his wedding, and it was great. And I think Adam was there too. Remember? So, yeah, I mean, these are tough, and like they're very intense, and you can really build up a lot of animosity, and you really got to try to keep a lid on it because you know, you have to keep working with people afterwards, and you don't want to get a reputation of being an idiot.
All right, and if I could just sum up in this way my own thoughts. You've got, as David says, a really tough job to do, especially in these multi-accused cases. And it's an important job. The role of defense counsel, of course, is fundamental to the administration of justice, and judges appreciate that. You always want to do the very best you can for your client. That's your professional obligation, and that's the expectation that every client should have of you. But having said that, always when you go into a trial, or for that matter, any kind of proceeding, always remember that you've got professional obligations, and the paper highlights this, particularly in this area of criminal practice. Those obligations include an obligation to act fairly, to respect the rules of evidence and of procedure, and to abide by the rulings of the trial judge, which one of the defense counsel in the Pollock case did not do and was excoriated for not doing so by the Court of Appeal for Ontario. You may not like the ruling that the presiding judge makes. You may think it's dumb. You may think it's 100% wrong as a matter of law, but it's a judicial ruling, and you must abide by it. The Court of Appeal and the Supreme Court of Canada have made this clear in multiple decisions. I can tell you, though, if you conduct yourself in this way, fairly, abiding by rules of evidence and procedure, abiding by rulings of the trial judge, you are going to earn a reputation, not just as an experienced and knowledgeable defense counsel, but as a defense counsel on whom the judiciary can rely. You will earn the respect of your colleagues. Nathan and David, you can see, have the utmost respect for one another, despite the fact they may, on a case-by-case basis, have differences of opinion. And you will earn the respect of opposing counsel and of the judiciary as well. And as has been said by smarter people in other contexts, the value of all of that is absolutely priceless. So thank you for your time today, and thank you to David and Nathan for their hard work.
Thank you.
I just want to thank everyone for agreeing to this beautiful reunion. And I totally don't believe that David had nothing to do with his client's father being called. And we have one question.
You brought up an important point that alerts me to ask the question. When you've got issues of bad character that play into the client's request not to go after a certain co-accused or any of the co-accused, and they send you an email that says, I don't want you to use any of the evidence I'm about to tell you, even though it would make sure I'm found innocent. Like, where do we say there's an obvious power imbalance in these co-accused where we would say, this is maybe one of those situations we need to look at other options? Or do we always just follow our client's instructions, document it, keep it clean, even when we see these obvious power imbalances?
If a client instructed me that I can't use the evidence that I feel is necessary to secure an acquittal, okay, and I'm highlighting that part that I feel is necessary to secure an acquittal, and I feel they're doing that because they're pressured, by the G code or something else, then I would do everything in my power to convince them that they're wrong, and then I wouldn't just go along with it after that. Something would happen, I might try to withdraw, or I might do something, but I wouldn't allow a piece of necessary exculpatory evidence to be left off the table.
Yeah, sometimes you have to think about getting off the case too, or using a threat to getting off the case to try to convince the client to make a decision in his best interest.
Thank you.
All right, everyone, we're about to go on a brief recess. There's some refreshments available. We're back at 11:15. Thanks, everyone.